evidence of criminal defendant's good character. In evidence law, even though we have this rule against character evidence, but in a criminal trial, the defendant is permitted to introduce evidence of his good character. So in a criminal trial, the defendant is permitted to introduce his good character evidence. That is permitted. So let's look at these two examples, and suppose we have this trial. The defendant is on trial for criminal assault. And in this case, the defendant may ask a witness to testify, to come to court to testify that he has a reputation of being a peaceable person. We understand why the defendant wants to introduce this evidence. He wants the jury to think because he has a reputation of being a peaceable person, so for the prosecution to say he committed this criminal assault, that is out of his character. So jury may reason because the defendant has a reputation of being a peaceable person, it is unlikely he actually committed this criminal assault. So we know that is a character evidence, but the defendant is permitted to introduce his good character evidence in a criminal trial. In the second example, suppose the defendant is on trial for embezzlement. He may ask a witness to testify that he has a reputation of being an honest person. That is also permitted. So the same reasoning process. The defendant wants the jury to reason because he has reputation of being an honest person. So for the prosecution to say he committed this crime of embezzlement, that is out of his character. There is one point we need to take note. That is, even though the defendant is permitted to introduce character evidence, this evidence must be relevant. So in the first case, when the defendant is on trial for criminal assault, he may introduce character evidence to show he has a reputation of being a peaceable person. In the second case scenario, the defendant is on trial for embezzlement. So he may introduce character evidence to show he has a reputation of being an honest person. The point is, if the defendant is on trial for criminal assault, he cannot introduce character evidence to show he is a person, he has a reputation of being an honest person, because this honesty has nothing to do whether he would commit a violent crime or not. So if the defendant is on trial for a violent crime, he can only introduce evidence to show he has a reputation of being a peaceable person. But if the defendant is charged with a crime involving dishonesty, if the defendant is on trial for embezzlement, for shoplifting, and then he may introduce evidence to show he has a reputation of being an honest person. But of course, if the defendant is on trial for embezzlement or shoplifting, of course, he cannot introduce evidence to show he has a reputation of being a peaceable person, because that would be irrelevant. So that point should be noted. Why we permit the defendant to introduce this his good character evidence? Sometimes we call this rule the mercy rule, because in a criminal trial, the defendant, if convicted, and he may lose his liberty in some cases, and he could face capital punishment. So the law wants to permit the defendant to introduce any evidence in his favor, in his defense. So that's why even though the prosecution is not permitted to introduce character evidence to attack the defendant's character, but the defendant is permitted to introduce his good character evidence in his defense. But there is also a point we must take note, that is, even though the prosecution is not permitted to introduce character evidence, but once the defendant introduces character evidence, the prosecution may do the same. Meaning is, if the defendant decides to open the door to this character evidence, and then the prosecution may also introduce character evidence. So in these two case scenarios we discussed, if the defendant is on trial for criminal assault, the defendant may introduce evidence to show he has a reputation of being a peaceful person. To counter that, the prosecution can introduce evidence to show the defendant has a reputation of being a violent person. So in this case for embezzlement, if the defendant introduces evidence to show he has a reputation of being an honest person, the prosecution may also introduce evidence to show the defendant has a reputation of being a dishonest person. So whether, even though this defendant is permitted to introduce his good character evidence, but the defendant must be aware once he introduces his good character evidence, the prosecution actually would be permitted to introduce his bad character evidence. So that is which way the defendant should go. The defendant should weigh his option carefully in this situation. Now we understand, even though we have this rule against the character evidence, in some cases, character evidence can be introduced. If, for example, if the defendant would introduce this evidence first, and then the prosecution may also introduce character evidence. So we know in some cases, character evidence is permitted. And then we have this issue, how we can prove this character. That is methods of proving character. There are three ways for us to prove this, for the parties to prove character. One is reputation evidence. The second one is opinion evidence. The third one is specific act evidence. It is important for us to note reputation evidence and opinion evidence is permitted in proving the character. But specific act evidence is not permitted. It is very important for us to remember this. Reputation evidence is a witness may come to court to testify saying that the defendant has a reputation of being an honest person. That is reputation evidence. Opinion evidence is a witness may come to court to say, in my opinion, I know the defendant for maybe 10 years, for 15 years. In my opinion, the defendant is an honest person. So that is what we mean by this reputation or opinion evidence. Specific act evidence is the witness would tell a story. For example, if the witness would come to court to testify, I know the defendant for 15 years. In my opinion, the defendant is an honest person. And to prove my point, I also want to tell you a story. Once the defendant was in the supermarket and he picked up a wallet and then he handed over to the store clerk. So that is this story is not only about his opinion. It's that he offered some a specific act. He's talking about a specific instance, a specific act performed by the defendant to show the defendant is an honest person. But this evidence is not permitted. Maybe we tend to think if you only say in your opinion and then the defendant is an honest person, maybe that is not persuasive. And if the witness can really offer some proof can tell some story as to why he formed his opinion that the defendant is an honest person. Maybe you think that evidence actually is more persuasive. But this specific act evidence is not permitted. The reason for not permitting the specific act evidence is this. Because if the defendant's witness would come to court to say once the defendant picked up a wallet and then he handed over to the store clerk, we know the issue right away would arise whether this story is true or not. So the prosecution probably would not accept this story. Maybe the prosecution would say this story could be false, and then how do we know the defendant actually performed this honest act or not? And then in that case, if we really want to prove whether the defendant indeed performed this honest act or not, maybe we want to do some investigation. We want to have this store, like managers or maybe clerks, to come to court to testify. We can do all the things, but we need to understand why the defendant is on trial. The defendant is on trial for shoplifting. We want to prove whether the defendant committed this crime of shoplifting or not. It is not the issue we try to figure out whether the defendant on a particular occasion performed a good deed or not. That is not the issue. And then, of course, we know in this case it is only one story, and then the defendant's witnesses and could tell maybe 6 or 5 stories. And then if that is the case, if we spend time try to figure out whether those stories of the defendant's honest deed or good behaviors, whether those stories are true or not, the trial is going to be distracted from the main issue. The main issue is whether the defendant committed this shoplifting crime or not. That is really why the defendant is on trial. We can say we cannot really care less whether the defendant performed a certain good act or not. So to save judicial resources, we would not permit any party to introduce specific act evidence. They could only introduce reputation or opinion evidence. So if the parties would only introduce opinion or reputation evidence, we would not have this issue that we need to prove something. The defendant can offer witnesses to come to court to say the defendant has a reputation of being an honest person. That's fine. And then if the prosecution wants to counter that, and then the prosecution may ask witnesses to come to court to say the defendant has a reputation of being a dishonest person. And then that is the end of the testimony. We do not have to investigate anything. We do not have to do any to present any further proof as to whatever. That is the two witnesses' different opinions. So this evidence would go to the jury. Which opinion the jury, which testimony the jury would want to believe, and then that is up to the jury. So we would not have this waste of this trial time, and then we have to present other evidence. We would not have all those issues. But if we permit specific act evidence, we know there would be an issue of a proof. But we also know whether the defendant performed an honest act or not. That is not the focus of the trial. The trial should focus on whether the defendant committed this shoplifting crime or not. That is the reason why specific act evidence is not permitted in proving character.